We're going to go through Chapter 1 today, and the focus of Chapter 1 is the purposes, scope, and sources of criminal law. And so let's get started. The first two slides here are going to be the learning objectives for Chapter 1, identify the branches of government and their relationship to the criminal law, to describe the difference between public law and private law, to list reasons people commit crimes and why they do not. We will understand the 4 generally recognized goals of the criminal justice system, and we will know the meaning of police power. That's a pretty popular topic right now, so that'll be an interesting discussion when we meet. We will identify the general limitations on the exercise of the police power by government. We'll describe the classifications of crimes and the principle of legality. We'll list and describe the 5 specific constitutional limitations on the power to create criminal law. And we'll define circumstances that would make a criminal law a status crime, which by definition you'll also want to know what a status crime is. Trace the origin of the common law to its place in criminal law today. So those are the 10 learning objectives that we're going to go through in Chapter 1. So criminal laws and the criminal justice system are essential parts of the democratic system in America. Without the laws that we have, the country would be in anarchy. We are starting to see some of that today with the breakdown in the systems of government. And those systems of government that we need to talk about are the legislative branch, which enacts laws, including criminal laws, the executive branch, including law enforcement agencies, which enforce the laws, and the judicial branch, which determines the guilt or innocence of those charged with the violations of laws. So you can see how the 3 branches of government are interrelated in the criminal justice system and how they're integral to each other's success. So without the legislative branch making laws, the executive branch would have nothing to enforce, and without anything to enforce, the judicial branch would have nothing to adjudicate. So those 3 independent branches of the government are independent, but they also are interrelated with one another. And that's probably the most important thing you can learn in this class, is those 3 branches of the United States government and what they do for the criminal justice system. The first branch of government that we'll talk about is the legislative system. Laws are enacted by the legislative branch. So in the federal government, that would be the legislature, the House, and the Senate. The state is dependent on the state that you're from. In the state of Maine, it is the House and the Senate in the state of Maine, which is the state legislature. And at the local level, you also have local laws that are passed by your city council or town board. The chief executive officer participates in the legislative process by signing or vetoing proposed laws. That's the way that the chief executive officer can use their influence to try to get the legislative branch to enact laws that the executive sees as necessary, and to actually not enact laws that the chief executive sees as being something that would be detrimental to society. The executive branch includes agencies with which administer and enforce the laws. For example, law enforcement agencies are found within the executive branch and are charged with enforcing criminal laws. Additionally, the correction system is found within the executive branch. So the executive branch encompasses both law enforcement and corrections within the criminal justice system. So the third and final branch of government is the judicial branch, and this encompasses the courts, both local, state, and federal. The state and federal trial courts hold jury trials unless the defendant has waived their right to a jury trial under the Bill of Rights, in which case the judge is the fact finder. In some cases, that's more beneficial or seen as more beneficial to the defendant. The state appellate courts decide appeals for state prosecutions, and the Federal Circuit Court of Appeal decides appeals for federal prosecutions. And there's a extremely limited review of state and federal convictions by the United States Supreme Court under certiorari. Certiorari is a term that you'll hear often. We'll talk about it because that's how the United States Supreme Court hears a case. And finally, the habeas corpus relief can be sought in federal courts, but only after other appellate avenues have been exhausted. Habeas corpus is nothing more than asking the correctional facility holding the person to bring that person to court, and it means to present the body. So more technically, a writ of certiorari is the written request of a court to hear a case. If it agrees, the court issues order to lower court for its case materials, and if the writ is denied, the conviction is final unless post-conviction relief can be found. Our federal court system is broken down into the trial courts at the federal level. Those trial courts coincide with the 11 districts plus the District of Columbia and federal lands. And each district has a corresponding appellate district court. Okay, so let's talk about the public and private law. Public law applies to all in a jurisdiction. So it is the criminal law side of the courts. And this is true in both the United States and the United Kingdom. So that's where public law comes in. Private law is between parties. Generally, it includes contract violations and disputes. And then substantive laws define and regulate the criminal conduct. So those substantive laws are what gives us our how we actually operate. So this is an interesting experiment. The idea of criminology and criminalistics, they're oftentimes thought of as very similar, and they really couldn't be any more different. Criminology is the study of the sociological and psychological causes of crime and criminal law making, whereas criminalistics is the use of science and scientific testing in court to bolster evidence presented. So our criminal law here in the United States comes it has its origins in England. Originally, no laws were codified in England. Kingdoms would realize the wrongs that happened in one area and were also typical in another area. So by the early 1600s, they came up with mandatory rules of conduct, and the English judges put those out. The royal judges believed that their decisions represented the best interest of the king, and those interests were sent out to the different shires, and they had sheriffs that oversaw each shire, and they would implement the codified law or the written law there in England. And that's where our American criminal law system comes from. Some of the major documents that influenced the law here in the United States were the Magna Carta out of in 1215, the Mayflower Compact, which was nothing more than an agreement between the men on the Mayflower as to how they would conduct themselves here in the new land. The English Bill of Rights in 1689 gave us a launching pad for our Bill of Rights here in the United States. Obviously, our Declaration of Independence was the founding of our country and how gave the format for the foundation of the country. And then the U.S. Constitution, which wasn't ratified until 1788, gave the government that we had established in 1776, it gave it its right to operate. So for 12 years we operated under the old system because we hadn't actually put one in place. And then the Bill of Rights took another 3 years to get into existence. They weren't codified until 1791. Some of the classifications of criminal law, it can be substantive criminal law, which is public law defining conduct prohibited or mandated by legislative act or judicial decree. That means that any law that is put out by the legislature is a substantive criminal law, that if it's on the public law side, so the criminal side. And criminal procedure are just the rules regulating the process of investigation and prosecution of violations of criminal law. So if you think of criminal procedure, think of the procedure that the criminal will go through from the time that they are encountered by the police till the time that they're put in to the system, booked into the jail. And if they're bailed, that's also part of criminal procedure. How do they get their first hearing, which is notification of their crime that they're alleged to have committed? And then how does the trial take place, and what are the avenues for appeals? That whole system is criminal procedure. Statutory, common law, or administrative rule, we've already talked about all of those. And then the terms that you're well aware of: felony and misdemeanor, felony being the more substantive of crimes, and misdemeanor being the lesser crimes within society. And they are deemed within society to be either a felony or a misdemeanor, and that can change over time. So we have seen crimes go from felony to misdemeanor, and we've seen crimes go from misdemeanor to felony. And you'll also see some other different types of classifications of crime. I've seen felony misdemeanors in some cases, which is generally an in-between category in some states. So this will depend on what state you're in. So we've talked about the law and we've talked about the procedure. Let's step back a minute. What is the purpose of criminal law? Why do we even need criminal law? Well, like I've said a couple of times, the people have determined that they need some protections in place to regulate the actions of people so that the society as a whole can feel safe. So they identify conduct prohibited or mandated. And it's important because we need to be able to keep society running properly without interference from criminal activity. Punish those who violate criminal laws. Why should violators be punished? Well, without that punishment, why wouldn't people commit crime? Now, I understand that some people wouldn't, but more people would if you don't punish them. It's set up to protect society from dangerous people. What are some of the likely results if society does not feel protected? Are we going through that today? Is that something that we're feeling with what's going on in a lot of our inner cities? Portland, Oregon, we're seeing a lot of this right now. So is that a problem? Is that something that we feel safe. Reform or rehabilitate convicted persons. This is a big debate that is always goes on. Do statistics point to the success or failure of this goal? Well, we'll get into that a little bit this semester. And then we will definitely talk about the differences between criminal versus civil law when it comes to the purposes for law. So there's a lot on this slide, but I really think it's important. When you start off at the left-hand side, it says conduct to be regulated. So this is where we determine if the conduct rises to the level of a criminal offense. So murder, rape, felonies, theft, misdemeanors, and so on. Or is it a civil offense? Speeding, overtime parking, those types of offenses are more on the civil side of the ledger. So within the criminal offense, you have it broken down, felony and misdemeanor. The book breaks it down into A, B, C, D, and E felonies, and then A, B, and C misdemeanors. Here in the state of Maine, we have A, B, and C felonies, and then our misdemeanors are just categorized as D and E. Civil offenses are found in state statute and in county and city ordinances, as we talked about earlier. Civil offenses are punishable by fines and forfeitures, such as loss of the driver's license, but cannot be any point imprisoned for a civil offense. So the next 4 slides are probably my favorite slides during this this first chapter. The constitutional limitations on criminal laws. We did talk about this a little bit in our discussion forum this past week. So the states have the general inherent power to make criminal laws. The federal government can only enact criminal laws where the U.S. Constitution gives them the power to do so. And that falls under the 10th Amendment to the United States Constitution. Additionally, we see that the U.S. constitutional limitations on state and federal power fall under the First Amendment, which protects the individual's freedom of speech. The Second Amendment, which protects the individual's right to bear arms. The Eighth Amendment, which prohibits cruel and unusual punishment by the government. And the 14th Amendment, which gives us the due process rights of the individual, and Equal Protection Clause, which is equal protection under the law for every citizen of the United States. So no ex post facto laws can be created. What does that mean? Article 1, Section 9 and 10 of the United States Constitution forbid the U.S. Congress and all states from enacting ex post facto or after the fact laws. So what that means is that no state or the U.S. Congress can create a new crime and make the law retroactive so as to punish conduct that was lawful at the time in which it was conducted. So another constitutional limitation that is very important, it's terminology that you're going to want to know, nulla pena sine lege. That is no punishment without a law. So the principle of no punishment without a law for it makes perfect sense, but it is a basic principle of both the English and American law. So nobody can be punished for something that there isn't a law for. So this is a little different from the ex post facto. Ex post facto, the Congress has decided that we need to have a law for something, and that just says that you can't go back and be punished for something that wasn't against the law when you did it. This one means that there can be no punishment without a law. So that just means that if there is no law on the books, you can't be punished for committing that because there is no crime. The next few slides go over the individual's right to due process, their deprivations of life, liberty, or property. And so the due process requirements in the Fifth Amendment to the United States Constitution for federal laws, and then the 14th Amendment basically carried that requirement over to the state laws, so that the state governments must also provide due process. It basically limits the manners in which government can use criminal laws to regulate conduct. Void for vagueness. So this is an interesting decision that we can see come up. This is when a law has to be specific and not so vague that men of ordinary intelligence must necessarily guess at its meaning. And so this comes up generally in court decisions. That's where statutes will be nullified for void for vagueness. Overbreadth doctrine. This is where laws actually go way too broad. So if a law says that all people driving between 5 o'clock and 6 o'clock at night can be stopped for any reason, that would be overbreadth. The scope of the law is not reasonable under the, in that case, under the Fourth Amendment. And so you can't allow, the justices cannot allow a law to be overbroad. The Equal Protections Clause in the United States Constitution basically limits criminal laws so that they have equal effect on and application to all persons that are subject to the law. States can make classifications for purposes of application of a criminal law, but only if they are reasonable. Where the classification is based on suspect criteria, the criminal law is permissible only if the state shows it is absolutely necessary, so that's called strict scrutiny under the law, to achieve some permissible state purpose. Classifications based on race are inherently suspect and are subject to strict scrutiny. So when we look at Equal Protection Clause, it means that the laws have to be equally rendered to all people who are subject to the law. The last two slides are just thinking points, and these are things that I would like for you to do outside of class. I'm not going to cover them here. We just finished up the slideshow for Chapter 1. I just wanted to make you aware that the thinking points are there as the last two slides in the Chapter 1 PowerPoint. So we will see you again in Chapter 2.